Everyone for joining us. Today I feel blessed because Joseph McGuire has agreed to redo his presentation from a few weeks ago because after I lost it. So thank you for offering to do this. And we actually have a bigger group this time, so that's exciting. And I'll let you set it up, Joseph, in terms of I know that you're okay with taking questions kind of throughout.
I am.
So
I have some breaks here for questions. Yes. So
and today's topic is FCC, the Layman's Guide to FCC, including fair use.
Well,
or copyright.
Well, let me share my screen.
Okay.
There we go. I think everybody can see my screen now.
Yes.
So this is the copyright and fair use, the tension between creators and users, a layman's explanation. I am not a lawyer. I might have played one on Radio Theater Project once or twice, but I will not pretend to be a lawyer. If you really need true copyright advice, I recommend going to a copyright lawyer. Anyway, so let's talk about what is copyright. Copyright is the protected expression of a creator's idea in a fixed format. And that's the last two words are the most important part of that. It's a fixed format on paper, like it was originally, but originally a dance choreography was not in a fixed format, so choreography could not be copywritten. And
someone else who wants to know about it too.
Anyway, so that's, and there's a long history of copyright, and what copyright means is protecting a person's ideas that are in these fixed formats, because it's easy to copy something. It's easy to hire a copyist. Nowadays, you just get a copy machine or you put it on the internet. And so this is to protect people and their intellectual property. And that's what really copyright is. There's also the patent and trademark, but those have different angles that are not covered by this session. So here's a brief history of copyright in the US, because copyright is a national product that's created by each state. And so this is to cover the United States. The patent and copyright clause of the Constitution is real easy: to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So that's where copyright comes in. It's supposed to protect what you make. But people have agreed on, at least they did in those days, that it should be a limited time. So throughout the years, starting with 1790, they created laws to promulgate this clause. And one of them is that 14 years, renewable for 14 years, meaning that you were protected for 14 years and you could renew for another 14 years. So a total of 28 years. And these all progressed over the time as we went from the late 17th century or 18th century to the 19th century to the 21st century. And so then somewhere in the 1850s and 60s, they decided to attack some aspects that were not covered in the original act. So they made it 28 years, renewable for another 28 years. New protections for expressions like musical works when you wrote notes on paper. Protection of filmed works, that when film became a way to fix an idea or a intellectual property. And then musical works could also be fixed in a form called recordings. And so that's when the 1909 Act, which was a completely revised act, it was brought out by a progressive Theodore Roosevelt and a progressive Republican Congress that decided they needed to rewrite the laws. So not only did it cover the notes that you wrote on paper, but originally it was also to do what was called a pianola. And people call them player pianos. You see them in Westerns. You see the jokes, I'm playing a piano, and then you show the reel, and it's just not. But pianolas. But at the same time, Edison came out with being able to record on cylinder. And so that was covered too. And then, of course, later discs, when they went from wax cylinders to uh, shellac cylinders, and then they went to discs. And part of this 1909 law, and this is how it is effectively figured into our industry to a degree, it's called the compulsory license for recording music. If you had the right to mechanically reproduce or record published music after paying a set license fee, and they could not turn you down. You had to take this set license fee if you wanted to record like a song. So someone would publish, and there was something called Tin Pan Alley where people would sell songs to publishers, and then publishers would put it out there. They get one person to record it, and then other people, because of that, could record it too. And we call that covering. But in those days, they just called it, we want to sing the song. They wanted to license it so they could sing the song. And the publisher and the writer wanted a top star to sing the song. They wanted Bing Crosby to sing the song, who's had dozens of #1 songs. That's who you wanted to sing your song. And so this compulsory license was so that the publishers couldn't just hoard the music and then parcel it out. That was the progressive aspect. They could they had to basically license it, so everybody made money. Now this was the writers and the publishers. The singers made their money by being paid by the recording companies or paid by the music sheet companies or paid by the pianola companies. You know what I mean? So then we go through another period of time where pretty much the copyright stayed the same until 1972. One of the things about the original Copyright Act, because recorded music on cylinders and discs, and then later other forms, were not covered by the copyright. They were a fixed form, but they were not covered, so it was not covered so that you could play them as you wanted. So starting in 1972, they brought from 72 forward phono copyright into the Copyright Act. And at the same time, starting in the 50s, they were also deciding to rewrite the Copyright Act. And so by 1976, they passed the 1976 Copyright Act, which there was a treaty, an international copyright treaty called the Berne Convention, like in Bern, Switzerland, which, being an international treaty, countries could subscribe to it. And we decided to go with the Berne Convention and eliminated renewals, eliminated a specific set number of years. So we came up with life plus 50. So that means person's life, when they died, then they would last 50 more years, then would go into public domain. Automatic copyright, meaning that if you wrote something in fixed form, it was automatically copywritten by the state and covered by injunctive relief, meaning you could stop people from copying it by enjoining them or getting a court to have an injunction. Or you could copyright, register it, and then you could get statutory damages, meaning if someone made money off of it or they took money away from you, you could sue them for statutory damages for 3 years. And then in 1998 was the Sonny Bono Copyright Term Extension Act, adding another 20 years for life plus 50 became life plus 70. the Digital Copyright Millennium Act, which covers the digitization of music and how it was, you could stream it, play it on YouTube, things like that. And the Music Modernization Act, which brought in some more aspects, one of them being making recordings before 1972 under copyright. And I know that's a whole lot to talk about, so I want to have a little question session. If anyone has any questions that I can answer, go ahead and unmute.
Nothing from me yet. Anyone else? Looks like we're good so far.
Okay. And if anybody wishes to ask any questions, go ahead. So the next step, we're going to talk about what is the public domain. Well, the public domain means that anyone can use it. It is not protected by any state action. And at this time, anything before 1927 in the United States is in public domain. Works that were published without a copyright notice before 1977 are also in public domain, as those published before 1989 if the copyright was not registered within 5 years of the date of publication, and those published before 1964 if the copyright was not renewed for 28 years. And that's a lot of information to understand, and that's why you can come back. But you can also go to Stanford, and they have the stanford.edu, just type Stanford copyright, has a whole bunch of stuff on this. And one of them is they added a database. So in 1976, they added the ability to, like the Library of Congress or the Copyright Office, you could supply a digital version of your work, and then they would put it into a searchable database, not of the work, but of the registration. And they would put it in a database, and you would type at the copyright a name or author or work, and you could find out if it's in copyright. Before that, it was all on paper. The Stanford University has been digitizing them and adding them to a database of their own. You can also go to archive.org and look it up and see the PDFs of all the paperwork. Or in a lot of cases, if you want to really make sure, you hire a lawyer.
And what was the Stanford website again?
Exhibits.stanford.edu copyright renewals.
Exhibits.stanford.edu. Sorry.
/ copyright renewals. That's okay.
/
But if you just type copyrightstanford.edu, you can probably get most of what I talked about. So is there anything you want to know, any questions on public domain?
Could I just clarify everything published before 1927? That's like a living thing, right? Next year it'll be 1928.
Yes.
Okay.
Very good point. I should cover that. Starting 3 years ago. It used to be 1923 4 years ago, forever. And then starting 4 years ago, it began moving forward a line. And we'll talk about a little bit about people pushing back about public domain in a little bit later in the session. But there's any questions on public domain? Just want to underscore this. If it's in public domain, it can be used for whatever purpose you want. You can use it. Your next door neighbor can use it. You can both produce plays, movies. The underlying copyright or public domain work is completely usable. Okay, moving along. Copyright for radio and podcast creator. Here's a big one. Fair use. Legal thicket involving all other uses of copyright work. There's transformative factor. There's the nature of the copyrighted work, the amount, substantiability, that's a tough one, substantiality of the portion taken, and the effect of the use upon the market, potential market. And this is where I'm just going to cover briefly because it is truly a thicket, but I'm going to give you some tips. Fact or fiction. Facts can be used from a work of a nonfiction. Fiction works are more highly protected. In other words, if you wanted to use a reference work in a work that you're creating, let's say you're writing a play about a specific time, and you read in a book that this happened and this happened, then you can use that in the fiction work. If you want to use a piece of fiction, you can't use it as easily. And that's where it comes into how much is too much. There is no bright line on how much is too much. No amount of time, no amount of words. You have to look at the heart of the work, which is highly protected. But you do get quoting for educational, nonprofit, or review is allowed. And who tells you whether you can or not? A judge. Someone sues you for copyright infringement, sends you a cease and desist letter. If you don't decide just to trash can the project and you hire a lawyer of your own and you go to court, the judge will say, sorry, or the jury, sorry, you used too much, or sorry, you didn't use enough, or you did use just the right amount.
There was a lawyer that told us that made it really clear, like if you want to use fair use, that means you have to be prepared to use it in court.
Yep.
Right.
Very good. So any questions on this? Either I'm covering this well or you're all bored.
I think you're doing great.
Well, thank you. All right. Profitability. Fair use cannot harm the author by reducing the earnings from the work. Now, this is another case where, again, this is all based on lawsuits, but like if you take a work and you use it and then that stops someone from being able to sell their work because, well, they, I've already read your work. I don't need to buy your work. And such, just basically reducing the earnings from the work because it is all about protecting someone's intellectual property. Transformative. Here's one of the few possible bright lines. Parody. That's because this has been covered all the way to the Supreme Court. And this was Campbell versus Acuff Rose Music Incorporated, or the Two Live Crew Pretty Woman parody case. Now, this is parody. They didn't say satire, they said parody, but meaning you're making a comment on the work. And in the case of the Two Live Crew, they were creating showing that it was an anti-feminist work by using profane and crude language. And so they sued. The Supreme Court said it's parody. It is absolute fair use. But some of the things that they also said was you only get one bite at the apple. You can't keep parodying the same song. You also can't use something like a song to parody something else. Weird Al, who writes comedy songs using people's songs, music, he generally gets permission because he's not making fun of the song. He's not making a comment, a parody. Probably, yes?
Talking to me?
Yeah, I'm sorry.
Oh, yeah, yes, I was just going to note, Marie noted Weird Al put that, she noted him too in the chat.
Yep, thank you. I haven't seen the chat, I'm sorry.
Oh, that's okay, that's what I'm here for.
Good. Anyway, so parody is a bright line, but make sure that you're parodying what the work, not something else using the work. Um, that's one of the things about, we go back to the compulsory license. You're not allowed to change. You can change instrumentation or stuff like that, but you can't change the work without having to pay them extra for licensing directly. So there's a lot of people who reject this overly protected expression, and a lot of people have come up with reason or ways of going around it. One of them is open source. Now, one of the things is from what I understand, if you put something into the public domain, you can never take it out. If you say, this is public domain, here you go, everybody can use it, you can't bring it back. That's what I understand. But open source, copyleft, Creative Commons license, Lawrence Lessig's lawsuit over the Sony Bono Act, which made it life plus 70 years. The Supreme Court said, yes, 70 years is limited. They never stated if 70 years was a limitation. 1 day less than forever, that's a limitation. So you got to be careful about that. So we don't know. So there's, what they came up with is a unique contract called the Creative Commons license. And I won't go over the whole entire one. You just type in Creative Commons and you will see, but it allows you to control it completely. It allows you to allows you to have non-derivatives, or you can derive from it. It allows you to only use it as non-commercial work, or you can be used as a commercial work.
When you say derivatives, what do you mean?
Well, meaning you want to turn it into a parody, or you want to do what Weird Al does, and you don't care. It's a derivative work.
Okay.
It's derived from the work by doing something else. It's a way of overcoming fair use, strict use of fair use. So you're saying you can make derivatives. They also say you also have to say that you made a strict derivative of my work. So you have to tell people. And so they have a contract. So you say, I'm going to use this Creative Commons license, and then they give various names, and then you know what you can do with the work. And it's still copywritten. You can still change the Creative Commons. You could bring it back into the regular copyright. You can relicense it. You could hire a lawyer to write a contract any way you want. It's just a short way of letting people know how you want your work used. That doesn't mean you have to put it in public domain and never get any protection or money. Because, basically, you want to be a musician, not a ditch digger. You want to be a writer, an artist, not a telephone repairman or woman. And so you want to make money off your work. What's wrong with that?
Right.
I see nothing wrong with that.
Right. Marie has another question. Does FCC have any regulation or comment on copyright public domain?
No.
Okay.
No. Everything. So I guess I'll talk a little bit about this. I hadn't thought of this, but creative or copyright is generally handled in civil court. Meaning cease and desist letters, hire lawyers, go to court, get a jury, get a judge to say what is good, go the way of the Supreme Court like Lawrence Lessig did. And then it's handled. The state can, because it's written in the law, go after you for criminal penalties. As you see it every time you open up with a DVD, it says, and that's a very good line. It says, even if you're not using this to make money, it's still against the law. But most of the times, people just hire lawyers and go to civil court.
Okay.
So that's pretty much the end of my session, my pre-recorded session, so to speak. And so I'll stop sharing.
Okay.
And
are you comfortable if we keep recording for questions, or would you rather? Okay.
Yeah, go ahead.
I asked this one last time, so I'll kick it off. And I
Mm,
know, did we? Well, we can talk. I know Marie had a question too, that you were going to get into.
let me turn up the chat here. Okay.
Okay. So, do you remember when I said, oh, right, we've had people, we've encountered people with shows who want to read the news. And Ursula and I have talked about this at length, like, because it sounds like from what you're saying, like, technically, you can't just read the news. Like you said, you have to do just facts.
That is correct.
But it also sounds like a lot of people do it anyway.
Yes.
So it creates this limbo world that we live in.
Let me say, just because since last time we talked, I have been reading my 3-book series, The History of United States Broadcasting, book 1 through 3 by Eric Barnow. And this is how radio started. In both cases with music and news, they said, hey, we're giving you free publicity.
Right, exactly.
But that's not why the newspapers, who were losing advertisers, and the musicians, who were losing money, felt about it. So they had to come up with options, which is eventually they got AP and UPI to have a news service that you subscribe to, because they want to make money for all the, they have to support the stringers and the staff writers. And so they need to make money too. But if you take a local news article and you trim it down to, so there's this article all about this car crash, and they talk to all the people who were there and stuff. So what you basically can do is you can say there was a car crash on 98th Street. There was this many injuries, this many fatalities, and pretty much that's it.
Yeah. And I know the people who've talked to us who've been wanting to read the news anyway, they say, well, I cite the author if it's a magazine article or.
I've heard the citation angle before, and I've heard it from a lot of people. What does the author get for the citation? It's the
Not
same old
money.
story.
Right.
It's the recognition. Oh, look, we're giving you publicity, so you what? Sell more newspapers? I mean, sell more books? Now, if you're using the articles to in a broader work that you're talking about your local news, how it's like uh, it's got a specific. Let's say you're working on a story and you think that they have a specific bent to the news, and you want to use quotes from those articles in your work, that can be considered fair use. But just to read it straight out, no, that's not fair use.
Right. And Marie says if you write a news story based on several sources, variety of newspaper articles, what about that?
That's
Like,
fine too, as long as you just use the facts. You again, let's say they interview this person, which is the heart of the story, and so you take a quote from this interview. Isn't that getting to the heart of the story? And you're using this person's or this organization's creative work in your work, but it's not, you are not the one being creative, they're the one being creative. That's the heart of the work, part of fair use. And they could easily say that we've lost money because of this, because no one's going to bother reading the original, because they got it on a news bite.
hmm.
I like these questions. I love them.
Any other further thoughts on this? Joseph said, Orozco says, how about sources taken off the internet?
Um, what sources? If it's open source, it's fine. If it's closed source, as some would say, or copywritten, it's not fine. It's the same thing. You look at the organization, you look at what they're doing, and you follow the fair use rules. There is no free place unless it says it's open source or it's free. And like, for instance, if I'm looking for clip art, a lot of that clip art I got was I just typed in open source clip art. And I found open source clip art places that say this is to be used for whatever reason you want. What's the name of the radio station back east that created a library of open source music?
WFMU.
Yes. Do they still exist?
Yeah, the library still exists.
Yes. Well, people were willing to let people use this for non-commercial radio stations. That was a, say, Creative Commons derivative or license. And so you know for sure that you can use that work on your, of course, then we cover ASCAP, BMI, and CSAC and the music licensing organizations. But that's the reason is because they have control over the publishers have given them the control over licensing the music to public performance.
Ursula.
Joseph,
Yes.
if you say you're doing a radio show and you want to talk about an organization that has a website, if they have information on their website about who they are, or some announcement on their website, is it legal to read that and say, according to the ACLU, their mission is blah, 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 and you read their mission?
Well, I can tell you that I think it would be fair use because you're not taking the heart of the work. You're not, then of course, what I would do is I would go to the organization and say, hey, you want to do a Skagit Talks interview?
Yeah, but I mean, what if they have an article on their, homepage that has information you'd like to use? Can you quote that?
If it's, well, I really, it's a hard case to say without knowing exactly what it would be. Is it a nonprofit organization? Is it a commercial organization? I would say, the reason I'm not saying yes or no is because I'm not a lawyer.
So in other words, it's not automatically a given that if it's on a website that it's public information?
Absolutely not. That one I can say for sure. The internet is not a free source of information unless they say it's a free source of information. Mm. People always like to grab the picture of the guy and put it on their webpage. And the webpage was built for sharing. But not everybody wants to share. It depends if people want to share or not and how. They have their website derivative that you could use a Creative Commons. If you see a Creative Commons badge, it says it's okay to use this work as long as you're cited, then you're good. You're golden. If there's no Creative Commons no Creative Commons license, then you know that it's just strictly whatever's copyright, and then it's lawsuit time, possibly. How about recording people reading timeline facts found in a published article sidebar and used as a dropped-in audio clips? I think this is a question. The facts, you're just using a timeline. So if it's just the facts, yeah, it would be fine with me.
Maybe you'd have to put it in your own words.
Yeah, I would. You always should put it out in your own words. This week in history, you can say this week in history in 1842, this happened and this happened. In 1875, this happened. In 1909, the Compulsory License Act was passed. It's just a facts. Follow the fair use, four-step fair use, and you're pretty well covered. Now, there are certain organizations that love to send out cease and desist letters because, well, they hope to capture one guy who's actually doing something wrong and get them their money. I mean, there's copyright trolls like there's patent trolls. You got to beware of those. There's people who send out pictures as sort of, well, you can, they don't say you can use this picture, but it seems like the site says you use this picture. But when you use this picture, they send a cease and desist. So I always look directly for words like open source or free, which leads me to this royalty-free music that we were talking about previously.
Can I interject another question before you go?
You may.
Okay.
You may.
I see there's a couple more from Marie. She noted that many years ago, BMI pinged her about music. She said she was using original music, and BMI told her that no longer existed, and she needed to join them, which that sounds very troll-like. But
it no longer existed as music, or I'm not sure
original
exactly.
music no longer exists.
Oh, I see what they're saying. Well, you know what? Here's how you cover your local band who's created their own songs. Get them to write you an email permission. If they're not member of ASCAP, CSAC, or BMI. If you want to use that as a theme song, get their permission in email. Then you're covered.
Then one more about she's citing like an educational angle. If you use a story, reading a whole news article or paragraph, and then commenting in writing form, that sounds to me like you'd kind of be making it your own.
If you read the whole article, you're not.
No, not if you read the whole article. If you use a piece of it and then make it into, that would be a fair use argument. It wouldn't be like a guarantee, but it would be a fair use argument,
yes,
right?
It would be a fair use argument. And you also, because you're an educational organization, each one makes it rise higher for fair use argument. And you're using it for review purposes. I mean, people use these. If you read the New Yorker, they have these long, giant articles with lots of little bits and pieces they use.
Right.
But of course, they have more lawyers than I do.
Right. Maybe it's a little different for writing too, because you cite it in the article. Right.
But the citing isn't more important in the fair use than how are you using it.
Right. Right. But but the New Yorker article is its own thing. It's just got little bits. Right. We got more questions coming. Marcus asks, are promos for shows permitted to use licensed music?
Well, now we're going to get back into what I was going to talk about in royalty-free music.
Okay, let's do that.
Okay, so if you go out and use the Star Wars theme as a promo, you haven't gotten permission in a fixed form to use that in a promo, because it's not been licensed as royalty-free music. It's been licensed to play in performance, public performance, by being on a record, being on a tape, being in a digital form. Those are public performances. You're not playing them without something that makes them a new thing. Okay. And so if you don't get permission, and it used to be you could go to a place called the Harry Fox Agency, but they got rid of that a dozen years ago. Now you have to go directly to the owner or license holder of the music. If you go to a website that is defined as like a royalty-free music service. Now, the term royalty-free kind of confuses people because the word free is in there. It did me at first.
Yeah.
What they mean is in the old days, back with records, and someone would come in and say, I want to use this to make a commercial at a radio station, they would do what is known as a needle drop charge. So every time you played that, you would have to send them a penny, a nickel, a half a cent, whatever, every time you dropped the needle into it. That was sort of how they looked at it. Then there's royalty-free, meaning you don't have to pay a needle drop charge. So you pay $500 for a 99-year license to use it any way you wish.
Oh, okay.
Meaning you can make derivatives, you can do whatever you want with it. That's what royalty-free music is. And you have to go to places. It used to be you would buy stacks of records that would have royalty-free, and some of them would be needle drop charged, or some of them would give you a 99-year license. And then you would, how in the old days you used to make things. Nowadays you go to a place and it says royalty-free music, and you pay, and music cost is very expensive. You can pay up to hundreds and hundreds of dollars for this royalty-free music because it's not free. It's only royalty-free. No needle drop charges.
Okay.
And so you can license for hundreds and hundreds and thousands of dollars the Star Wars theme, or you can go to a production music house and get a sound like made on a kazoo.
Or is it sometimes where it sounds similar, but it's just like one of the phrases in the song is like inverted or something, so it's...
Well, they're very good at coming up with ways of making it sound so that they don't get sued.
Yeah.
And unfortunately, I find production music very mind-numbing. But I found some good production music out there, so it isn't all bad. But you got to listen to a lot of it before you find the right one. Or you can go to your local musician, and he can, if he's good enough, he can create you something, and then you can pay him for that and directly, and you don't have to license it, or you're licensing it directly from him or her. And you can.
And there's one release for the artist, and there's one for the recording, right? So assuming that's what we found out with a Sprouts show.
Yes, for this has to do with the Compulsory License Act of 1909, is that, and then later copyrighting the actual work, is there's two streams. You're right, but a person who does both, who hasn't like maybe published their work, can give you everything.
Right.
But yes, that's why the Beatles didn't own their own music, and Michael Jackson wound up with it because while Capitol Music owned the recordings, the publishing house owned the music. And then the publishing house was purchased by Michael Jackson and so forth and so on. So Capitol owns the tapes and now the digital recordings, and the publisher, sheet music, which is what it was originally for, was separate. That's why there's two streams.
If there's some more questions, will that throw you off, or do you want to wait?
No.
Okay.
No, I was done with that royalty-free thing.
Okay. Let's see. We're back. Marie says the key is published. Oh, what? The key is published date. If Agamemnon.
Oh,
okay. I obviously don't know this reference. If
Agamemnon, he was a Greek guy.
Okay. If Agamemnon just discovered a newly published, what would public domain be?
It wouldn't be in the public domain, from what I understand, because it's a work that has never been published, and the publishing starts at the time that you were published. So if in 2022 someone published it, there would be copyright in that work.
Mm-hmm.
Agamemnon was the king, wasn't he?
Yes.
He was the king of Troy or king of the Greek?
Believe
he was king of Troy.
Yeah, he was king of Troy.
Oh, Marie, reaching way back.
So, well, I think she's saying if they found a new work by what was his name? Homer.
Oh, right on. Yeah.
Of course, he spoke, and so in his world, in our world, if he just spoke his words, it wouldn't be in a fixed form unless he taped it.
Okay. Wow, good one. That was a good one.
Oh, thank you.
How about newspaper reporters reading their own paper story on a radio segment as a program of local newspapers? Oh, if someone read their own story, that's what you're saying?
Now that's an interesting point of view that I didn't really bring up, and I think it's a good line to bring up. And that's something that is perfectly actually that is something that is to the that only is in the United States. It's called, wait for it, works made for hire.
Okay.
It's in the law, in the 1976 law. If you are using an organization's computers, typewriters, they're what they own, and you're hired to do this, it becomes a works made for hire, meaning the copyright is automatically transferred to the organization and out of the hands of the person who's the author. And so probably if it was a work made for hire, which is just, he was just, getting paid a wage at a newspaper, he could probably be sued if he read his own work. Because he's the author, but not the owner. If you have contracted, and I'm going to give an example, which I like to do, a historical example. Before the work made for hire was put into the law in 1976, when a writer or artist, specifically for comic books in the 30s and 40s and 50s and 60s, when they signed the back of the check, it signed a contract that said this was a works made for hire. Even if they were a freelancer, even if they did their own work at their own studio. So you have certain things that you have to be involved, but you can also still sign a contract saying it's a work made for hire.
It's good to know.
Yes.
One more question from Marie. I was wondering this too. Is there a website you would recommend for theme music or production music?
Actually, yes. It's an aggregator of all sound effects and production music. It's called Sound Dogs.
Sounddogs.com?
I believe so, yes. And I found this out early in the days of Radio Theater Project. And so, as an example, to publish my Radio Theater Project works into the world, whether I give them away or not, has no meaning to this. I couldn't just go to the store. I don't know if anybody remembers those sound effects. 101 sound effects for your party. They're not licensed for commercial or non-commercial work that you're distributing. They're licensed to put it on your record player and have a party. And so I went to a place and researched this. This was a little bit in the early days of the internet. And I purchased a set of science fiction sound effects, 3 discs that held maybe, 3 discs worth of sound effects, and 4 discs worth of just general or science fiction sound effects, and 4 discs that were just general, everyday, kitchen sound, stuff like that. And I paid $350 a piece for them. And that was back in the old days. Not for the disc, per set.
Okay.
Yeah, but actually, and nowadays, of course, you just go to a website and Sound Dogs will allow you to purchase individual sound effects, $2 here, $5 there, or you can buy sets from different organizations. You can buy the $1,000, everything you ever need for sound effects, and it'll download to your computer, and then you have a 20 gigabyte hard drive.
Yeah, there is a lot of those websites too, so I'm glad that you listed the one you like.
Yes. Well, it's only because it's an aggregator. It's got a lot of people putting their stuff on, so you don't have to be stuck on
Gotcha.
one thing. And they even have a nonprofit rate, an educational rate. I'm sorry, an educational rate gives you like 20% off.
Nice.
But they also have royalty-free music, and you'll see the difference. You'll type in sound effect, let's say hammering. And it'll say, 10 seconds of hammering for $2, $3. Well, I want a hammer. I want a song that sounds like I have a hammer. Oh, look, it's $500. It's $400. It's $200.
Yeah, yeah, yeah. It's a really good hammer.
And there's a couple of websites, and it's hard to if you look for there's a guy named Kevin MacLeod, spelled McLeod, and he has a website that gives away music. You have to give it. It's a Creative Commons license, and you have to give you have to cite their work, who made it, the author. And there are other people who can sometimes give away work. You look for websites and say, oh yeah, we're going to give away 10 songs just because, we want to show you how good our work is. Always make sure to read the license, make sure that it is royalty free, and how you can use it, because they're tricky.
That sounds it.
Yes. Audionautics.com, and I don't even know how to pronounce or spell that. And I've used some. I found several good pieces that I've used in Radio Theater Project for themes.
They are out there.
A little bit of history with television. I like Perry Mason, the old TV series, and I never noticed until recently that they never had a music composer. Everything was from the CBS Music Library. The only thing that was composed was the original theme.
Oh wow!
So
That's
you can
cool.
you can hear music from some movies. I mean, I've heard that music in that movie.
You could even use the same one. Oh no, it's the CBS Library. It's not Commons.
Yeah, it was for the producers, because the CBS owned the show, because that was in those days they owned TV shows, and then it came back and they now started owning TV shows.
You guys know about the one for Star? I think it's in Star Wars. I think it's a Steven Spielberg related. I wish I could. It has a name. Oh, it's called the Wilhelm Scream.
Oh,
Have
yes.
you guys heard of that? And it was from some old movie, but some editor or something got wind of it and used it in like Star Wars and Indiana Jones, and you'll just find them in all action movies all over the place. And it's basically like the sound of someone falling off a cliff going like that. And it's like a secret Easter egg that.
Yes, it's actually been used since the 50s.
Yeah.
If I remember correctly.
Anyway, anyway.
Well,
I mean, I guess it's everyone borrowing, so in a way it relates.
It is, but how much do you need to have? Okay, here's an aspect of copyright. What can be copywritten? Well, we know fixed works, but they do have to be artistic. Much to the world's chagrin, or much to the world's unhappiness, back in the early days when they didn't have OCR, optical character reading, they sent telephone books off to Malaysia to be typewritten into databases. And is that against the copyright? Well, the Supreme Court said no, it's not an artistic work. It's just a list of facts.
Mm-hmm.
So all those books became the reason why we get calls that I might have just gotten.
Oh, that's cool. I didn't know that.
Yes. There's copyright that's thin, where it's an artistic work, but it's kind of not an artistic work. There's edge cases, but I couldn't give you an edge case.
Yeah, it really is another thing I've learned from lawyers. It really is a case by case basis.
It is.
Yeah.
Is there any more questions?
Look at the chat here. I don't think there's any.
Someone just held up their finger. I like your questions. Your questions are great.
Way to go, team. Did someone raise their hand?
Yes, she's typing, I think.
Oh, okay. Gotcha.
Yes.
Right. Yeah.
Encyclopedic articles. Well, That's a good question. I don't know if I have a good answer. The entire article, that may be the thin copyright edge. There's not really any artistic work, but it is a work that they depend on to make money.
Hmm.
You know, looking for free stuff is okay, and if someone says it's free, it's free. But trying to come up with ways to make it free when it isn't really helpful for anybody. Maybe I'm being a little depressed, and I mean, that's why I love the Creative Commons systems. That's why I like the idea of open source, because these are people who say, hey, we don't want to sell LibreOffice. We want to give it away. And
Right.
but here's an interesting on open source that I just remembered reading an article about. There are all these people who are contributing to these open source works who are not getting paid. And a lot of them are just doing grunt work, and people write to them angrily, this doesn't work, it has a bug. Well, what do you expect? They're doing this out of the kindness of their heart. If they were being paid for it, maybe I could see a little anger. But if I pay $400 for a software that's buggy, you bet I'm going to get upset. But if I get something open source that's buggy, well, I'm just going to say, well, hey,
Right.
I've tried
It's
their
kind
best.
of at your own risk. Yeah.
Yes.
And they don't have the time maybe to keep up
So,
with it.
Wikipedia is a Creative Commons work. They say you can copy it and do as you wish with it. And I remember that there were people who would take the entire articles of Wikipedia, put them into a little Kindle book, and sell them on Amazon.
Oh my God.
It's actually not against the law. It's not against copyright, because they said you can do as you wish with this.
Wow.
And they would fool them with like title, all you need to know about, or things like that. I don't think they exist anymore, but I used to see them all the time on Amazon.
Wow.
And any other questions?
Did we answer all your, I know you had some at the beginning, Marie. Did we get to those? Yeah, okay. Anyone else? I see we're going over we're after 4. Any other closing thoughts that you have, Joseph, that we didn't
No.
get to, or?
Not that
Okay.
I can think of. We covered some things that I didn't think of in my little presentation, which was good.
Yeah, you covered a lot of different bases.
Pretty much that's all I have to say.
Okay. Well, thank you again. This was great. I always appreciate having you, and you're always fun and informative. So thank you.
Okay.
Oh, thank you from Marcus in the chat.
Well, I appreciate there's many people who came. I appreciate that.
Thank you, Joseph.
You're all
That was
very
great.
welcome.
Although you really kind of bummed me out, but it was great.